never slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast. I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all the past. And the pettiness, a reflection of the emptiness. Hilarious, you think you're with my time, you're delirious. Mysterious, because you are behind a fake exterior. Inferior, you know I'll always be a bit superior. Get off of me, this ain't no humble brag. I want you to hear words, you can say them back. I want you to feel free from the chains that last, and to believe in what you got, it was built to last, yeah. Now that I've been put through, I never got anyone's help.
Hey everyone, I hope you're doing well. Today we're going to go over new documents in the Kohberger case. And I wanted to let you know that I am working on a new intro. I am going to get rid of all the pictures, and I have a new song, and I hope everyone will see it when it's done. I just trying to make it kind of aggravating to me because it's my first one I'm doing on my own. So whenever I get stuck and get frustrated, I have to like put it and stop until I'm okay, and then I start, and then I get frustrated, and then I stop. So hopefully it'll be done soon. Hopefully I don't have to pay somebody to do it for me. I don't know, but let's these documents. Most of them are one page, but there's one that's like 18 pages long, and we know I'm the best reader at all these documents. That's what I thought. I'm just joking. Let's go. Oh, I'm gonna take my overlay off so we can see documents. There we go. Let's see if I can make it bigger for you. All right, I hope that's good for you guys to read. Let's go. So this is defendant's fourth supplemental request for discovery. I'm not really sure why the prosecution is taking so long to turn this information defense. Let's see what's going on with it. Please take notice, undersigned pursuant to Rule 16 of the Idaho Criminal Rules, the 4th, 5th, 6th, 8th, and 14th Amendments to the Constitution of the United States, and 1, 2, 13, and 16 of the Constitution of the State of Idaho, request discovery and inspection of all materials discoverable by defendant per ICR, and the aforementioned constitutional provisions, including but not limited to the following information, evidence, and materials outlined in the attached Exhibit C. And there's no attached Exhibit C. Note that the defense is saying that the prosecution has exculpatory evidence. I know that the defense wants certain things from the jury hearing. Hey, how are you? I just don't understand why they don't want to turn everything over. I know I don't. How many days they have left to let them know if it's going to be a death penalty case or not, which absolutely I'm pretty sure that it will be a death penalty case. Let's see. This one is order to file Defendant's Exhibit C. Okay, there it is. Order to file Defendant's Exhibit C attached to the defendant's fourth supplemental request for discovery under seal. I still don't see it. Court having before the defendant's stipulated motion to file Exhibit C attached to defendant's fourth supplemental request for discovery under seal and cause appearing now therefore. It is hereby ordered that the defendant's Exhibit C attached to their fourth supplemental request for discovery shall be filed under seal pursuant to ICAR 2I, 2D, and E, and IC 74-I-24, 1B, and C. Huh. I want to know what Exhibit C is. Thanks, Lily. I am. Thank you so much. The weather was not as bad as they predicted last night. Penelope was very afraid of it, of course. But she usually, the thunder scares her. And if it's like pouring really loud, and you can hear it hitting the house or something, she'll go under the bed. Thunder and loud rain, she will go under the bed and hide. I don't know. Okay, so this is the motion for protective order. This is the one that's like 18 pages long, so you guys give me a second to get a sip of drink and smoke my vape real quick. I really appreciate you holding on for one moment for me. You guys, this is really a lot to read. Don't forget, tonight I'm going live with information on the Titanic, on the Titan, the submersible that's missing. They actually have 1 day left of air. So tonight we're going to go through that. Okay, here we go, guys. Are you ready? All right, motion for a protective order. This is from the prosecution. Comes now the state of Idaho by and through the Latah County prosecuting attorney and respectfully moves the court for a protective order pursuant to ICR 16-1 for information related to investigative genetic genealogy. This case arises from a quadruple homicide. Law enforcement found the DNA of a potential suspect at the crime scene, and the FBI submitted the DNA to one or more publicly available genetic genealogy services to determine potential relatives of the suspect. The FBI then used common genealogical techniques to develop a family tree leading to defendant. The state seeks to protect from disclosure the names and personal information of the hundreds of innocent relatives on the family tree, the names of the publicly available genetic genealogy services used, and certain other information described below. The disclosure of this information is not required by Rule 16 of the Idaho Criminal Rules and should be protected from disclosure for the good cause described below, including the state's privilege to protect the identity of informers as described in Rule of Evidence 509. Factual background. I think this is the one that says they did a DNA testing from his cheek, and it came, okay, I'm just going to read it. On November 13, 2022, law enforcement found the bodies of Madison Mogan, Kaylee Gonzalez, Xander Kernodle, and Ethan Chapman at 1122 King Road in Moscow, Idaho. All 4 victims died from apparent knife wounds. Law enforcement found a K-bar knife sheath on a bed next to the bodies of Madison and Kaylee. The sheath was face down and partially under both Madison's body and the comforter on the bed. Law enforcement seized the K-bar knife sheath pursuant to a search warrant. The Idaho State Police Lab in Meridian, Idaho, located DNA on the K-bar knife sheath. The ISP laboratory determined the DNA came from a single source, and that source was male. Once law enforcement had single-source DNA from the K-bar knife sheath, they conducted what is called a short tandem repeat analysis, STR. The STR DNA analysis involves looking at 20 regions within human DNA and allows law enforcement to make a direct comparison between 2 STR DNA profiles. Law enforcement submitted the STR DNA profile obtained from the K-bar knife sheath to the Combined DNA Index System, CODIS, a database of STR DNA profiles from convicted offenders, arrestees, and crime scene evidence to identify the source of the DNA. No match was found. Hey, Freeside. Hey, Miss Cole Langford. I like the way you changed your name. Unable to find a match using STR DNA analysis, law enforcement decided to use investigative genetic genealogy to find a lead. Genetic genealogy allows individuals to trace their lineage or connect with unknown family members using DNA. Typically, it involves sending a DNA sample, such as a tube of saliva, to a genetic genealogy service like Ancestry.com or 23andMe. Wait, whenever you sign up for Ancestry.com, do they send you something to send in your DNA in order to give you your family tree? Is that how that works? Lily. Is that how that Ancestry.com works? I never heard of 23andMe. I didn't know they use your DNA. I don't know anything about it. I wanted to try it, but I don't know. Let me know if you have to send in your DNA and that's how you get your family tree. You don't trust them? Okay, let's see. The Genetic Genealogy Service then creates a single nucleotide polymorphism profile to use for genealogical purposes. A SNP profile is different than the STR DNA profile and is used more often for genealogical purposes. The Genetic Genealogy Service then uses an algorithm to compare the user's SNP profile to SNP profiles submitted to the Genetic Genealogy Service by other users to determine ancestry and potential relatives. The Genetic Genealogy Service shares with the user a list of potential relatives, and depending on the specific Genetic Genealogy Service, personally identifying information on those individuals like their name, email address, and the amount of DNA the user shares with the potential relatives. Wow. The user does not receive any genetic information pertaining to other database users. Like users' DNA profiles are not shared with each other. The same process used frequently by members of the public can also be used by law enforcement as part of their investigation, a technique referred to as investigative genetic genealogy, or IGG. Once a publicly available genetic genealogy service shows law enforcement potential relatives of the suspect, law enforcement applies traditional investigative and genealogical. That's how they freaking found him. Methods, like they knew his dad was in PA. Law enforcement applies traditional investigative and genealogical, whatever that word is, methods to build a family tree in an effort to follow the tree to the suspect or a close relative of the suspect. They had his whole family tree from the sheath. Family trees can be used to narrow down a potential suspect based on factors such as age, gender, opportunity, known physical characteristics of the suspect, etc. Lily. In this case, investigators used IgG to begin the process of developing a lead to the individual who left DNA on the K-bar knife sheath. The Idaho State Police utilized a private laboratory to develop a SNP profile from the DNA on the K-bar knife sheath. The private laboratory started using genetic genealogy to develop a family tree, but after law enforcement decided the FBI would take over, the private laboratory ceased its efforts and sent the SNP profile to the FBI. The FBI uploaded the SNP profile to one or more publicly available genetic genealogy services to identify possible family members of the suspect based on shared genetic data. See, that's what causes more cost in these cases. They sent it to this a private laboratory, and because the FBI took over, they mailed it back to the FBI, and they sent it to someone else. That's like money being spent. The FBI could then view through the genetic genealogy services portal information regarding potential relatives of the suspect who left DNA on the K-bar knife sheath. Based on information the FBI could see in the genetic genealogy services portal, the FBI went to work building family trees of the genetic relatives to the suspect DNA left at the crime scene in an attempt to identify the contributor of the unknown DNA. The FBI built the family tree using the same tools and methods used by members of the public who wish to learn more about their ancestors. For example, the FBI consulted social media, viewed vital records such as birth and death certificates, and viewed other information already contained in the user portal for the genetic genealogy service, including unverified information submitted by other users of the genetic genealogy service. The FBI also consulted subscription-based databases available to law enforcement for information on individual people. The product of the genealogy conducted by the FBI was a family tree that contained the name, birth date, and death date, if applicable, of hundreds of relatives as well as their familial connections between each other and the suspect, Bryan C. Kohberger. The FBI then sent to local law enforcement a tip to investigate defendant. Can you guys understand me good while reading it? I hope you guys can understand the way I'm reading it. The IgG process pointed law enforcement towards defendant, but it did not provide law enforcement with substantial evidence of guilt. The FBI did not, for example, conduct a direct comparison between the SNP profile from the K-bar knife sheath and defendant's SNP profile. That type of direct comparison required the more traditional STR DNA analysis, which was conducted by the Idaho State Police, not the FBI. This is confusing. Prior to the FBI's IgG efforts, the ISP laboratory developed the traditional STR DNA profile from the DNA found on the K-bar knife sheath. After identification of defendant, law enforcement recovered trash from the home of the defendant's parent. An ISP laboratory did STR DNA analysis of items from the trash for comparison to the unknown crime scene DNA. That comparison indicated the DNA found on the trash belonged to the biological father of the individual who left the DNA on the K-bar knife sheath. Pursuant to a search warrant, law enforcement then collected DNA from defendant via a buccal swab. This is it right here. A traditional STR DNA comparison was done between the STR profile found on the K-bar knife sheath and defendant's DNA. The comparison showed a statistical match. Specifically, the STR profile is at least 5.37 octillion times more likely to be seen if defendant is the source than if an unrelated individual randomly selected from the general population is the source. 5.37 octillion times. Okay, I just need to take a breath. This is really a lot. Do you guys remember any of those, what any of those abbreviations mean besides FBI? I totally forgot. Okay, I bought a vape yesterday. It's cotton candy. Never again. I took one hit and I'm going to throw it away. The genealogy conducted by the FBI resulted in a lead that pointed law enforcement to defendant, but it did not result in the creation of many documents or records. Much of the information relied on by the FBI was only viewed through the user portal in the publicly available genetic genealogy services and other investigative databases. The FBI did not download or create copies of those records. Once the defendant was in custody, the FBI removed the S&P profile from the genetic genealogy services pursuant to the United States Department of Justice interim policy for forensic genetic genealogy DNA analysis and searching Department of Justice policy. That was a lot. This means the FBI no longer has access to view much of the information it used to create the family tree and cannot view it again without resubmitting the SNP profile to the Genetic Genealogy Service. To the state's knowledge, the only records that reflect the FBI's efforts to create defendant's family tree is the family tree itself. Notes jotted down by FBI agents as they constructed the family tree, and any records created to document the removal of the SNP profile from the Genetic Genealogy Services pursuant to the DOJ policy. The state has not seen, nor does the state possess, these records or copies of these records. Argument. The state seeks a protective order for a narrow category of information, namely information related to the use of IgG in this case. Idaho Criminal Rule 16 governs discovery in criminal proceedings. State versus Ish, 166 Idaho 492-510-2020 and 2020. Rule 16 is broad, but it is not a free-for-all. The rule contemplates the exchange of discrete categories of information between the state and the defense. As relative here, the rule contemplates the state will provide three discrete categories of information, or information that would tend to negate the guilt of the accused. Any documents or objects that are material to the preparation of the defense, intended for use by the prosecutor as evidence at trial, or were obtained for the defendant or belong to the defendant, and reports of scientific tests or experiments. If a defendant believes he should receive information that does not fall within one of the discrete Rule 16 categories, the rule allows the defendant to seek an order from the court for information where the defendant can show a substantial need for the information in the preparation of his case. Here, defendant served on the state a request for discovery that calls for the IgG information. Even though the IgG information falls outside of Rule 16, without first obtaining an order from this court, the state now seeks, and the court should answer, an order protecting the information related to the use of IgG in this case. Specifically, the state seeks to protect the following information. All right. So this is the reasoning why they are not turning over the discovery that they're asking for. The raw data related to the SNP profile and the underlying laboratory documentation related to the development of the profile, such as chain of custody forms, laboratory standard operating procedures, analysis notes, etc., All information related to IgG efforts in creating a family tree and identifying defendants' potential relatives, including the identities of the genetic genealogy services and the personally identifying information of defendants' relatives. The state does not seek to protect and has or will disclose the following information: a genotype kit report from the private lab utilized by the Idaho State Police, which documents that a DNA test was performed. Information related to the STR DNA analysis conducted using the DNA recovered from the K-bar knife sheath and the DNA recovered from defendant's parents' trash. Information related to the STR DNA analysis conducted using the DNA recovered from the K-bar knife sheath and the DNA recovered from the defendants via buccal swab. This court should grant an order protecting the IgG information in this case because the IgG information does not fit into any of the discrete categories listed in Rule 16, and good cause exists to protect the information, including the need to protect the privacy of defendants' relatives. Well, at least they're thinking of his family. Penelope is in her bed very mad at me. A. Rule 16A does not require the disclosure of the IgG information because the IgG information is not exculpatory. Is that what the defense thinks they have that's exculpatory? Rule 16A of the Idaho Criminal Rules does not require the disclosure of the IgG information because the IgG information does not tend to negate the guilt or reduce the potential punishment of defendant. The rule requires the state to disclose any material or information in the prosecuting attorney's possession or control that tends to negate the guilt of the accused as to the offense charged or that would tend to reduce the punishment for the offense. ICR 16A. As written, this rule largely mirrors the federal Brady requirement that the state produce to a criminal defendant all material exculpatory information. But Rule 16A and Brady are limited to exculpatory information. They do not require the prosecutor to make a complete and detailed accounting to the defense of all police investigatory work on a case. This is really, it gets harder to read as you see all these words and sentences want to merge together. While the question of whether IgG information must be disclosed as exculpatory is one first impression in Idaho, courts outside of Idaho have correctly decided that IgG information need not be disclosed as exculpatory. In Green, law enforcement used DNA recovered from the victim's nightgown to identify the defendant as a possible suspect. Then they recovered items from the defendant's garbage that contained DNA and found through STR DNA testing that the DNA in the defendant's garbage matched the DNA found on the victim's nightgown. A saliva test then confirmed that the defendant's DNA matched the DNA on the victim's nightgown. The defendant moved to compel the disclosure of the IgG information. After an in-camera hearing, the court denied the motion. The court explained, the evidence that is material to the defendant's guilt or innocence is the testing that followed the IgG investigation, which directly compared a fresh swab of the defendant's DNA with the DNA profile collected from the victim's nightgown. It is only this evidence that the people intend to present at trial. The people are not obligated to provide its preliminary search of the genealogy databases for possible matches, which is investigatory in nature and is not exculpatory or material to the defendant's defense. As this case illustrates, the state is not required to disclose the IgG information under Rule 16A because the IgG information the state seeks to protect is not favorable to defendant on the issues of guilt or punishment. The information provided to local law enforcement by the FBA was nothing more than a tip, a lead for local law enforcement to follow up on, should they choose to. The genealogical tip did not prove or substantiate defendant's guilt. Rather, the tip allowed local law enforcement to focus their investigation on defendant and obtain independent material evidence of his guilt, all of which the state has disclosed or will disclose. Specifically, with respect to DNA and STR-DNA analysis found, defendant's DNA matched the DNA collected from the Kohberger knife sheath. To the extent the IgG information has any relevance, the fact that it led law enforcement to defendant means it is inculpatory rather than exculpatory in nature. Thus, Rule 16a does not require the disclosure of the IgG information because it is not relevant to and certainly not favorable to the defendant on the issues of guilt or punishment. Rule 16b-4 does not require the disclosure of the IgG information because the IgG information does not satisfy any of the required criteria. The nature of the IgG information is such that its disclosure is not required under Rule 16b-4. That rule requires the disclosure of books, papers, documents, photographs, tangible objects, and buildings or places only when they are 1. Are material to the preparation of the defense, 2. Are intended for use by the prosecutor as evidence at trial, or 3. Were obtained from the defendant or belong to the defendant. ICR 16b-4. The IgG information does not satisfy any of these criteria. First, the IgG information is not material to the preparation of the defense. Defendant is charged with killing 4 people, not with being related to a particular person. The mere fact that uploading the completed SNP profile into a publicly available genetic genealogy service led law enforcement to relatives of the defendant does not affect the strength of the evidence against him. The strength of the evidence against DNA in terms of the DNA evidence depends upon the confirmatory result from the STR-DNA analysis between defendant's DNA profile and the DNA recovered from the Kohberger's knife sheath. Do y'all think that this information should be sent to defense from the prosecution, like the family tree, quote unquote family tree, the DNA of his parents? Do you guys think that that should be turned over to the defense? Do you think that it's part of his defense that they could possibly turn this around to make it seem like something else? I don't know if, obviously, the Brady law comes in here, and I think that the courts will approve this motion. I really do. Reading this so far, like, it's really not anything pertaining to the investigation. All they did was use it to fine him. As explained further below, the state intends to introduce the STR-DNA analysis at trial and does not intend to enter any evidence pertaining to the development of an SNP profile or the tree building process for inculpatory purposes. The state has disclosed or will disclose the information it has related to the STR-DNA analysis conducted in connection with the case. The immateriality of the IgG information to the preparation of the defense is perhaps best understood by way of analogy. The tip that came from the IgG process is no different than other types of technology hits that put law enforcement on the trail of a suspect. C. United States versus Johnson in Idaho, October 7, 2011. For example, in Johnson, law enforcement recovered a suspect's DNA from a ball cap left at the scene of a bank robbery. Oh, wow. Law enforcement ran the DNA profile through CODIS, which resulted in multiple hits, including the defendant. A scientist narrowed down the hits to the defendant, and law enforcement confirmed it was the defendant's DNA after acquiring a buccal swab from the defendant. The defendant moved to compel the other CODIS hits from the government, but the court denied his motion. The court explained that the DNA evidence material to the defense was a direct comparison between the DNA on the hat and the DNA taken directly from the defendant. The fact defendant was first identified as a possible suspect based on a database search simply does not matter. Here, the IgG information, like the initial CODIS hits in Johnson, is not material to the preparation of the defense because it only shows how the defendant was first identified as a possible suspect. There you go. That's very true. And that's why I think that the court is going to rule for the prosecution on this. Moreover, the IgG information could not support an argument from defendant that the law enforcement violated his Fourth Amendment rights by entering the DNA collected from the Kohberger knife sheath into a genetic genealogy service. A defendant cannot prove a violation of the Fourth Amendment without first showing he or she had a reasonable expectation of privacy in the place searched. State versus Mann in 2017. The Kohberger knife sheath was abandoned at the scene, as was the DNA inside it. Defendant cannot show that he had a reasonable expectation of privacy in DNA left at the scene of a quadruple homicide or in the genetic information of his relatives who voluntarily provided their own DNA to a genetic genealogy service. Okay, hold on one second. It said, okay, so I thought that the DNA on the Kohberger sheath was only on the button that you use to snap it shut. But, correct me if I'm wrong, please. This says the Kohberger knife sheath was abandoned at the scene, as was the DNA inside, not outside on the button, but inside. Defendant cannot show that he had a reasonable expectation of privacy in DNA left at the scene of a quadruple homicide or in the genetic information of his relatives who voluntarily provided their own DNA to a genetic genealogy service. See Pyro versus State in 2008. Holding defendant did not have reasonable expectation of privacy in water bottle from which officers recovered DNA, and observing that this court has found no case holding that a reasonable expectation of privacy should be determined by a suspect's desire to keep his or her genetic identity private. Additionally, the sheath and defendant's DNA left on the sheath were seized pursuant to a valid search warrant issued by a magistrate judge, which means the law presumes that the search was reasonable. State versus Hutton in 2022. When a search is conducted pursuant to a warrant, the burden of proof is on the defendant to show that the search was invalid. Second, the state did not rely on the IgG information to establish probable cause for defendant's arrest, did not present the IgG information to the grand jury, and has no plans to present the IgG information for which a protective order is sought as evidence at trial. If that wasn't sent to the grand jury, then why in the hell does he think that he needs it for his defense? If that wasn't even used to be indicted by a grand jury, why would they need it? Is this correct? So did I, question mark. Third, the documents and tangible objects encompassed in the IgG information were not obtained from defendant, and defendant has no property interest in them. To the extent the DNA on the Kohberger knife sheath once belonged to defendant, he abandoned that DNA when he left it at the crime scene of a quadruple homicide. Defendant has never had a property interest in the records that reflect the SNP profile developed from the DNA on the Kohberger knife sheath, nor has he ever had a property interest in the information gathered from the genetic genealogy services using the SNP profile, such as the information provided to the genetic genealogy services by defendant's relatives. In short, none of the IgG information the state seeks to protect came directly from defendant or currently belongs to the defendant, and thus Rule 16b-4 does not require its disclosure. Another break. I'm sorry, guys. This really is a lot to read. We're going on page 14. I think there's 3 more. 14, 15, 16, 17. And I think 18 is like the signature page. I think we have 3 pages left. Oh. Exactly, Lily. I don't understand that unless I'm like understanding it wrong, but it did say inside. So I don't know. C. Rule 16b-5 does not require the disclosure of the IgG information because the IgG information is not the result of a scientific test or experiment. Rule 16 also requires the disclosure of information related to scientific experiments, but it only applies to limited information. Namely, Rule 16 requires the disclosure of results or reports of scientific tests or experiments made in connection with the particular case. ICR 16b-5, emphasis added. The rule does not require the state to disclose what law enforcement does with the results or reports. Moreover, a process, procedure, or investigative technique is not a scientific test or experiment, merely because it involves the comparison of information or objects or requires the use of logic or reason. See State versus Matthew. Have to get ready for the day and be out the door at 4:15 a.m. Wow! Have a great morning, evening, afternoon, night, everyone. Thanks, Lily. Holding an officer's comparison of 2 keys did not constitute a scientific test or experiment because it was merely an observation of similarity between 2 keys. These were 2 types of scientific tests conducted with respect to DNA that fall within the purview of Rule 16b-5. First, law enforcement used STR-DNA analysis to compare the DNA on the Kohberger knife sheath to defendant's father and then to defendant. As required by Rule 16b-5, the state has provided the reports from those scientific tests. The state also provided other information related to the STR-DNA analysis because the state plans on using that information at trial. Hold on a second. What does the defense need this for? Are they going to try to turn around and say that it was done incorrectly so they could try to use it as a mistrial? I don't understand why they would actually need this information. Dude, they found you. You're the one that did it. How they found you? Oh, well. Second, the private laboratory developed the SNP profile from the DNA on the Kohberger knife sheath. As required by Rule 16b-5, the state will produce the report that documents that DNA test. Rule 16b-5 does not require the state to disclose how the SNP profile was used, and the genealogy the FBI conducted based on the DNA information does not constitute a scientific test or experiment. I think we've got it now. The DNA information does not constitute a scientific test or experiment. Kohberger. the FBI submitted defendant's S&P profile to one or more genetic genealogy services and were available to view potential relatives and access unverified data added by users in the genetic genealogy services. Starting with those potential relatives, the FBI engaged in traditional genealogy to put together a family tree that could lead them to the suspect. Putting together the family tree required the FBI to review sources such as social media, publicly available databases, subscription-based databases, vital records like birth certificates, census records, and historical newspapers. None of those actions can accurately be characterized as a scientific test or experiment. The product of the FBI's efforts was a family tree comprised of hundreds of defendants' relatives. Put simply, the family tree created by the FBI cannot accurately be described as the results or reports of scientific tests or experiments, and thus falls outside of Rule 16b-5. Good cause exists for this court to enter an order protecting the IgG information, and if necessary, the court should hold an in-camera hearing. The mere fact that the IgG information does not fall within Rule 16 is reason enough for this court to enter an order protecting the IgG information. But the state is not seeking the protection of the IgG information as an exercise in assonance. Instead, the state seeks to protect hundreds of innocent civilians from having their personal information, including their names, birth dates, and familial connections to the defendant in a high-profile quadruple homicide from being disclosed. That's a very smart idea. The disclosure of the IgG information risks harm not only to these indirect informants, but also to the genetic genealogy services used by the FBI and the IgG investigative technique. This court should follow the procedure laid out by Idaho's appellate courts to determine whether the IgG information must be disclosed. Providing the IgG information would require the disclosure of the identity of informants and prejudice the state. I will be good and be good at it, Lily. Don't worry about that. All right, what page are we on? 16. I think we might have 2 pages left. I don't know. Let's see. The process used to collect IgG information required gathering information from several informants, including the genetic genealogy services to which the S&P profile was submitted, and indirectly from the relatives of the defendant who hit on the S&P profile, pursuant to Rule 16. Disclosure must not be required of an informant's identity unless the informant is to be produced as a witness at a hearing or trial. ICR 16G2. The state has no intent of presenting the IgG information for which a protective order is sought as evidence at trial, which means none of the IgG informants will be produced as witnesses at trial. The non-disclosure of this information is consistent with the state's privilege to refuse to disclose the identity of a person who has furnished information relating to or assisting in an investigation of a possible violation of a law to one law enforcement officer. So if the court does not approve this, like, oh man, I forgot what I was thinking. That's what I was thinking. If the court doesn't approve this, then they might as well just take the gag order off, because this is messed up. If they have to turn over all these people's information, hundreds of people, their birth dates, their full names, all this information for all these people that are being put into this quadruple homicide case, that's not right. In my opinion, it's not right. As a general matter, we protect the identity of informants. The U.S. Supreme Court has explained to encourage the flow of information concerning the commissions of crimes to law enforcement. McRae versus Illinois in 1967. Such communications are discouraged if the informer's identity is disclosed. The court's words, written long before S&P profiles were used for investigative purposes, apply with particular force to IgG information. Both the genetic genealogy services to which law enforcement agencies submit a suspect's S&P profile and the customers of those genetic genealogy services who may unknowingly be related to a suspect would be less likely to make their information available if courts start requiring the disclosure of their information in criminal cases, especially in high-profile criminal cases, and that's right. C. Green, protecting IgG information in part because the court retains wide discretion to protect against the disclosure of information that might unduly hamper the prosecution or violate some other legitimate governmental interest. This court should follow the process laid out by Idaho's appellate courts to determine whether the IgG information must be disclosed. Rule 16 allows this court to enter a protective order for good cause, ICR 16-1. If the court finds it necessary to review evidence in camera to decide whether disclosure is required, the rule itself allows the court to do so. The rule expressly contemplates that, in deciding whether to enter a protective order, the court may permit a party to show good cause by a written statement that the court will inspect ex parte. ICR 16-1. If relief is granted, the court must preserve and seal the entire text of the party's statement. ICR 16-1. Thus, Rule 16, standing alone, provides this court with the tools it needs to review evidence in camera, if the court decides it cannot enter a protective order based on this brief alone. Idaho's appellate courts have further explained the process district courts should use when faced with precisely this issue: the need to protect both the state's interest in non-disclosure of the identity of its informers. McGray 386 U.S. at 309, and defendants' rights to receive exculpatory information. See State v. Wilson, 2006. In Wilson, for example, the court explained that the situation calls for a two-step process. First, the defendant must make a threshold showing that the information may be able to give relevant testimony. Wilson 142 Idaho at 435. If the defendant successfully makes that showing, an in-camera proceeding then provides an opportunity for the state to show that the informant's knowledge is not of such relevance that disclosure should be ordered. Idaho C. also State v. Farlow in 2007, relying on Wilson to explain the same two-step process. Once a trial court has concluded the defendant meets the initial threshold showing, it must then conduct the in-camera examination. Further, the Idaho Supreme Court has confirmed that it is desirable and proper to hold such an in-camera hearing before ordering or denying disclosure. Even if this court finds that the IgG information falls within Rule 16, this court should follow posts that Idaho's appellate courts have planted for the protection of informants. Defendants should first be required to establish that the IgG information is in fact relevant to the charges against him. If he can do so, this court should allow the state to present information at an in-camera hearing for the court to determine whether the IgG information must be disclosed. How you want a list of informants and all their information like you can so make hits from jail, dude? So the Wilson case explaining the in-camera presentation ordinarily may be made in the form of affidavits, but allowing the trial courts to examine witnesses as well if the trial court deems it necessary. Conclusion. We made it. Based on the above, the state respectfully prays for the court to enter an order protecting the IgG information from disclosure as it falls outside the purview of Rule 16. In the alternative, if the defense can establish the IgG information is in fact relevant, the state asks this court to conduct the requisite requisite in-camera hearing for the state to present information related to the IGG information and then enter a protective order under ICR Rule 16.1 that the IGG information is not subject to discovery and need not be disclosed by the states. Respectfully submitted, June 16th. And then all the... You guys, that was very hard to read. Very hard to read. Now we're going to go to state's response to defendant's fourth supplemental request for discovery. To the defendant Bryan Christopher Kohberger and counsel Ann Taylor. Comes now the state of Idaho by and through the Latah County prosecuting attorney and submits the following response to defendant's fourth supplemental request for discovery. The state incorporates its January 23, 2023 state's response to requests for discovery. February 21, 2023 state's response to defendant's first supplemental request for discovery. March 29, 2023 state's response to defendant's second supplemental request for discovery. May 12, 2023, state's response to defendant's third supplemental request for discovery. May 12, 2023, state's response to defendant's motion to compel discovery. And June 8, 2023, state's supplemental response to defendant's first, second, and third supplemental requests for discovery. As it fully set forth at this point, the state has and will continue to provide discovery in accordance with ICR 16 and applicable law. State's response to defendant's amended motion to stay proceedings. Comes now the state of Idaho by and through the Latah County prosecuting attorney and responds to the defendant's amended motion to stay proceedings, filed herein on June 15, 2023, by incorporating, as it fully set forth at this point, the state's initial objection to motion to stay proceedings, previously filed herein on June 15th. One more. Oh, let me make it bigger. Stipulated motion to file Exhibit C attached to the defendant's fourth supplemental request for discovery under seal. Is this it? Nope. You okay, baby girl? Comes now Bryan C. Kohberger by and through his attorney, Ann C. Taylor, public defender, and hereby moves the court for an order to file Exhibit C of defendant's fourth supplemental request for discovery under seal. This motion is made pursuant to ICAR 32 I2 D and E and IC 74-124 1B and C because, number one, the documents contain facts or statements that might threaten or endanger life or safety of individuals. 2, it is necessary to preserve the right to a fair trial. And 3, disclosure would constitute an unwarranted invasion of personal privacy. Okay, so that's the new documents that came out on the Bryan Kohberger case. In my opinion, they definitely should approve the court's request for not sending over the S&P DNA reports to the defense because honestly, it will do nothing to help them. It needs to protect the family / informants, as most of the family is being called informants. Excuse me, Penelope, mommy is live. You'll have to wait one moment. Thank you. Okay, I'm sorry about that, guys. So this is the new documents on the case. October 2nd is supposed to be the trial. However, yeah, the defense wants extra time because they don't have enough time to make a defense, and it's whatever. Just do what you got to do so that we can have a trial October 2nd. Thank you very much, Ann Taylor. Anyway, please hit that thumbs up button for me. Remember that we have the Swamp has memberships now. It's like $4.99, I think, for the membership. I would really, really appreciate if you help support this channel. StreamYard gets expensive there every month. But anyway, I thank you guys for watching. Again, hit that thumbs up, subscribe, hit the bell so you know when I go live. And I will see you tonight for information on the submersible Titanic touring missing vessel. I think they only have like a day left of air. So on that note, I will see you tonight on 6 p.m. Central. Thanks, you guys, and I hope you have a wonderful day.